All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the State of Arizona versus Stanley K. Kemmish, Jr., our criminal number 17-0417. Each side will have 20 minutes within which to present their arguments here this morning. The appellant may reserve some portion of that for rebuttal. However, it's up to you to keep track of the time on the clock in that regard. We have read the briefs. We've been through the record. We have conferenced the case. We're familiar, I believe, with the facts and issues raised by this appeal. So please keep that in mind as you make your arguments here today. We're recording these proceedings both by audio and video. The video will be available in a matter of days on YouTube for anyone who wants to watch it. But because we are recording this, I would ask that as you approach the podium to present your argument, that you identify yourself and your client for that recording. With that, appellant may proceed.
Thank you, Your Honor. My name is Joshua Smith. I represent the state of Arizona, Deputy County Attorney with the La Paz County Attorney's Office. May it please the Court. The trial court erred in holding that a physician's recommendation is issued under California's Compassionate Use Act is the equivalent of an AMMA registry identification card for the purposes of ARS Section 362804.03c. A recommendation under the CUA is not the equivalent of an AMA registry identification card, because a recommendation of the CUA is not subject to the same oversight as a state-issued card. Further, the trial court's interpretation of ARS Section 362804.03c places in the conflict with the rest of the AMMA. Initially, a physician's recommendation under the CUA is not the equivalent of a registry identification card. A registry identification card is defined as a document issued by the Department of Health Services that identifies a person as a registered qualifying patient. A recommendation under the CUA is not issued by any state agency and does not identify the recipient or the holder of the recommendation as a registered qualifying patient.
So under your view of the world, then the equivalent, as referenced in the statute, has to have some involvement by the government?
Yes, Your Honor. It has to be issued by a state agency.
Why is that?
Under the AMMA, Arizona resident can only possess medical marijuana if they are in possession of a state-issued card. The AMMA has adopted a clear policy in favor of state registration. Under the CUA with a recommendation, there is no state oversight. The CUA has a very broad definition of what can qualify as a medical condition for possession of a medical marijuana recommendation. So a state involvement ensures that there is no abuse. It also allows law enforcement to know that this document has been reviewed by a state agency and has been approved by a state agency. A recommendation under the CUA...
Hey, counsel, doesn't that... I mean, I've been to California. I know what is required to get a state card in California. You walk by, there's a doctor sitting there. He signs a note. You get a card right there on the spot. Isn't that pretty similar to what Arizona does?
No, Your Honor. The situation you describe is the CUA. In California, you can then take that recommendation from a doctor and apply with a state agency. In Arizona, you have to get a written certification, which is a written document from a doctor that identifies...
Okay, that's a letter.
Yes, Your Honor, that identifies the debilitating medical condition that a
And that would be the letter that we're talking about in California.
Yes, Your Honor, and then you must submit it to the Department of Health Services, who then reviews it and then will either approve it or deny it. In California, with the recommendation, all you have is the letter. An Arizona resident cannot possess medical marijuana with just the letter.
But that's not what the statute says, and let's go look at the statute. Under 36280403C, it says it's equivalent that is issued on the laws of another state that allows a visiting patient to possess or use marijuana for medical purpose in the jurisdiction of issuance. So it's talking about whatever documentation you have in the other state that will allow you to have medical marijuana in that state. Isn't that what the statute that I read to you just said?
Your Honor, my interpretation of the equivalence language is to make it clear that it needs to be the equivalent of a registry identification card, which is a document that's issued by the State Department of Health Services that identifies a registered qualifying patient. A recommendation.
But it says specifically that is issued under the laws of another state that will allow the visiting patient to possess or use marijuana for medical purposes in the jurisdiction of issuance. So as long as the documentation allows the patient to use medical marijuana in the jurisdiction where it was issued, then it would qualify.
Your Honor, a recommendation under the CUA is not issued. It's given by a doctor. It's not issued by any state agency. The issue with a recommendation under the CUA is that there's no set form for what a recommendation under the CUA has to be. A recommendation under the CUA by the statutes in California can be oral. The documentation under the CUA...
But we don't have an oral recommendation, so we don't need to decide that issue here today. But let's talk about if California only had, before they passed their card statute, and they had only the Compassionate Act, are you telling me that your position would be that nobody in California could qualify as a qualified patient in Arizona?
Yes, Your Honor.
So that
California has...
Even though there were laws in California that would allow a California resident to possess marijuana under the laws of that state, that they wouldn't qualify as a patient in Arizona?
The AMA was adopted to be specifically distinct from how California has it set up, Your Honor. California has now in place a state-issued card system. While it is optional, there is a state-issued card system in place in California.
Mr. Smith, why, if that's the case, why would it say in 36280403C, a registry identification card or its equivalent? So if it was registry identification card only, why would we have the extra language in there?
My interpretation of the or its equivalence language, Your Honor, looks at whether it's the issue of which department it's issued under. California's issued identification card in the California is issued by the Department of Public Health rather than the Department of Health Services, or whether the card is referred to by something different. The or its equivalent should thus be read as a catch-all to cover other state cards and to bring attention to interpretation that it needs to be issued by a state agency that identifies a qualifying patient. The Abdi Court, while its dicta indicated that that was their reading of that statute as well, when it said that it was only a registry identification card issued by another state gives a visiting qualifying patient the same protections as the AMMA gives to a non-resident or to an Arizona resident. Further, an interpretation of 362804.03C that allows possession of medical marijuana by a non-resident with just a physician's recommendation places 362804.03C into conflict with the rest of the AMMA, because it would be the sole provision of the AMMA that would allow possession of medical marijuana with just the physician's recommendation. And an Arizona resident cannot possess medical marijuana with just a written certification or physician's recommendation. The defendant in this case would be treated no differently than an Arizona resident who only has the written certification.
But this is only for a temporary period of time.
Well,
you can't buy marijuana in Arizona. He could only have enough to bring with that he or she brings with them from the other jurisdiction, correct?
Yes, Your Honor.
So we're talking about a patient from California or any one of the other 29 states that have legal medical marijuana that have a small amount of marijuana for a short period of time, long enough apparently to use it. And that we're talking about a very, very small subset of people that would be using marijuana in the state of Arizona.
Marijuana possession is still generally illegal under Arizona law, Your Honor. It's only authorized as permitted under the AMMA. Allowing non-residents to possess medical marijuana, which is the physician's recommendation, essentially affords these non-residents greater protections than Arizona residents are afforded under the AMMA. And Arizona voters, in voting to enact the AMMA, I don't believe would have intended to grant non-residents greater protections than they are intending to grant themselves when they pass the AMMA. Everything in the AMMA speaks towards state registration, having to submit your card to a state agency. It then becomes a conflict to allow this one provision of the AMMA to allow people to possess marijuana in Arizona with just a doctor's recommendation. Particularly in the case of the CUA, where there is no set statute that says what must be on the recommendation. A recommendation under the CUA and the defendant's recommendation, both his card and his written letter from the doctor, does not identify what the debilitating medical condition the defendant had, so would not give law enforcement an opportunity or the ability to determine whether the defendant would even qualify as a visiting qualifying patient while in the field. If it's a state-issued card, even if the officers can't check the California system the same way they can check the AMMA system, there is at least, by being issued by a state agency, the imprimatur that it is valid and that the holder of the card is authorized to possess medical marijuana.
Mr. Smith, with all due respect, your supposition about what the voters intended when they passed this act is speculation on your part, is it not?
Yes, Your Honor, though.
And with respect to what the legislature may have intended when it created this language, you don't have anything to support that either, do you?
All I have
that the legislature intended to or did not intend that if a person qualifies in another jurisdiction, that would not be recognized and honored in Arizona.
I do not have that, Your Honor. I just have the publicity pamphlet information, which includes in the arguments in favor, distinctly distinguishing the AMMA from the CUA.
And going back to what you said earlier, if they wanted to limit the types of ailments that could qualify as medical marijuana, they could have put that in the statute. Right?
Well,
because all it says is that would allow them to purchase marijuana, medical marijuana, in the foreign state.
Your Honor, the definition of a visiting qualifying patient makes reference to is essentially a non-resident or a resident in Arizona who's only been in Arizona for 30 days, who has been diagnosed with a debilitating medical condition. The AMMA provides a list of what is a debilitating medical condition. Under the CUA, there's a catch-all provision that says that a recommendation can be given to a patient for any condition for which marijuana can provide relief. So a visiting qualifying patient would have to still have a debilitating medical condition as defined by the AMMA.
But that's not an issue for us because that wasn't contested below, was it?
No, it was conceded that the defendant would qualify as a visiting qualifying patient below.
Okay, so the only issue we have to decide today, we don't have to decide about an oral recommendation, nor do we have to decide about whether or not a visiting patient has an ailment that wouldn't qualify under Arizona law. We only have to decide whether the issuing letter that allows Mr. Kemmish to purchase medical marijuana in California allows him to possess a small amount of marijuana that he purchased in California here in Arizona.
Yes, Your Honor. The issue is whether the defendant's recommendation under the CUA is the equivalent of an AMMA registry identification card.
Do you anticipate this issue being prevalent going forward? I mean, how many cases do you actually get in
my
Pius
practice?
County?
In my practice, Your Honor, I have yet to see a California resident with an identification card.
They always have a letter.
If they have if they have a document from California authorizing them to possess medical marijuana, it's a recommendation in my practice, Your Honor. I've yet, though the fact that a recommendation appears to be more prevalent than an identification card should not be the end of the issue. The recommendation has no state oversight. The identification card, for all pertinent purposes, is the equivalent of an AMMA registry identification card. An identification card is defined under California law as a document issued by the State Department of Public Health that identifies a person authorized to engage in the medical use of cannabis and the person's designated primary caregiver, if any. So the definition of an identification card under California law is the equivalent of a definition of an AMMA registry identification card under the AMMA, in that they both define it as a card issued by a state agency identifying a person who is authorized for the medical use of marijuana.
So necessarily, if somebody had a card from California and were pulled over by law enforcement would know that they are authorized to have a small amount of marijuana. So realistically, the only people that would be charged and you would see in your practice would be individuals that only had the letter. Would that be correct?
That's what I've seen thus far, Your Honor. The policy that, it's not an official policy, but my policy would be if I saw someone with a state-issued card from California, I would treat that as the equivalent of an AMMA registry identification card, and then the charging would only be if they had more than the allowable amount of marijuana.
Has that occurred?
Not that I can recall, Your Honor. I've only been with La Paz County since July of 2016, so I don't have extensive history, but in my practice, I primarily prosecute the drug cases, so I've yet to see a state-issued card, though I would treat a state-issued card from California as the equivalent of an AMMA registry identification card.
Thank you.
Your Honors, ARS 362804.03C provides that non-residents who possess a registry identification card or the equivalent are afforded the same protections as the AMMA affords the Arizona residents. Interpreting 362804.03C to only apply to people who possess a card issued by a state agency from another state thereby assures law enforcement's or clarity law enforcement. It avoids conflicting interpretations of the AMMA by providing the AMMA only provides to people who possess a state-issued card. The trial court erred then in ruling that a recommendation under the CUA is the equivalent of an AMA registry identification card. And I would ask that this court reverse the trial court's decision and remand this case for further proceedings.
Before you go, all right. California allows people to possess a certain quantity of medical marijuana with a letter from their physician. Is there any other state that has the same kind of dichotomy between registration card and letter? Either are okay?
Under the CUA, there is no limit. Under the medical marijuana program, I believe the limit is 8 ounces.
I'm not talking about the limit. I'm saying there's 2 ways to possess marijuana. The quantity is irrelevant. Is there any other state that has the 2 different methods of possession of medical marijuana?
I believe there are 2. I'm not intimately familiar with other states' laws. I know in my brief, in a footnote, I cited to an online resource that indicated that only 3 states have a state-issued card being optional. So other than California, I believe there are only 2 other states.
Okay. Thank you.
Thank you, Mr. Smith.
And I would reserve the remainder of my time.
All right.
Thank you, Your Honors. Todd Coolidge on behalf of Stanley K. Kemmish, the appellee in this matter. May it please the court, I am going to be very brief. I will tell you that this was the smallest brief I've ever written in my life, mainly because I won, and also because I think the issue is that small. As you discussed, there aren't many jurisdictions that have both the recommendation letter and an identification card. And I will tell you that in my practice all around the state, La Paz County is the only county that prosecutes possession of marijuana with a recommendation letter. Obviously, the AMA, you know what the purpose of that was, is to allow people to use medical marijuana. We stipulated to all the facts in this case. The biggest stipulation is that Stanley K. Kemmish fits the definition of a visiting qualifying patient, and I'll get to that in a moment.
Well, before you get there, because something you just said, that if the recommendation letter that Mr. Kemmish had, and this is a hypothetical, I realize it's not the facts of this case. If Mr. Kemmish's recommendation letter had been for an ailment that would not qualify under the AMA, would he still be allowed to possess marijuana in Arizona?
Absolutely.
And why is that?
Well, because under the full faith and credit law, I don't clause of the Constitution, we can't tell another state what they can give medical marijuana cards or medical marijuana for nor what they have to have in order to purchase and possess that. I can give you a quick hypothetical back.
Now, hold on, before you get any further. Let's assume Arizona didn't have an AMA.
Okay.
And they had, you stopped Mr. Kemmish, or the authorities stopped Mr. Kemmish, and he produced the letter. Could they still charge him with possession of marijuana?
If Arizona did not have the Arizona Medical Marijuana Act, absolutely.
They could put, so it's a crime.
Correct.
Okay, so if we say in Arizona that it's criminal unless you meet these, you possess it for these ailments, and he possesses it for a different ailment, why can't they charge him with possession of marijuana?
They could in that situation. I don't believe that
that was my question.
Okay, I don't believe that our statute tells other states what those ailments can be. It states what Arizona residents, the ailment they have to have in order to get one, but it doesn't state what other residents have. The only thing that talks about that is the statute that I just said that we stipulated to, and the most important one is visiting qualifying patient. Means a person who is not a resident of Arizona or who has been a resident of Arizona less than 30 days, who has been diagnosed with a debilitating medical condition by a person who is licensed with authority to prescribe drugs to humans in the state of the person's residence. There's more, but I don't need to go on any further. So, the important thing there is in that statute, our legislature did not talk about a registry card whatsoever, nor did it list what the debilitating diseases in the other state or that doctor has diagnosed have to be. And that's why Mr. Kemmish has the right to possess medical marijuana within the right limits in Arizona as a visiting qualifying patient. I think the trial judge got it absolutely correct when he said equivalent means equal in force, amount, effect, or significance. The word equivalent has more to do with the impact of the document rather than what the document is. If the legislature had desired for a visiting qualifying patient to have the same exact documentation as in Arizona, it would have written that, the legislature would have written that in the statute.
Well, and let me follow up with Mr. Smith's argument, and you can respond to it. And that is that 280403C says that whatever this documentation is, it is issued under the laws of another state. There isn't really a document that is issued under the laws of the state of California in this scenario, is there?
I believe there is, actually. I believe the doctor's letter of recommendation includes the law as to what they issued it. If you look in Appellee's appendix, I believe it's page 1, 2, and 3 are Mr. Kemmish's health facility card, the back of it, and then the third page of the Appellee's appendix is the letter of recommendation. And all of them list the statutes and the authority by which the doctor is issuing that letter. It cites specifically to the California Compassionate Use Act.
So, in your view, those documents combined become a de facto state certification or state documentation consistent with what Mr. Smith is arguing is required here?
Yes, I believe actually, he's saying it has to be a state agent. I don't know that it has, or agency. I don't know that it has to be a state agency, but these documents, the doctor's letter, states they're issued pursuant to these statutes. It's very similar to the exact same thing an Arizona resident would have prior to going to the Department of Health. The letter looks exactly the same. If you look at the applications, which are also part of the court record for both Arizona and California cards, they're exactly the same. And all you do, and it's part of the facts, we stipulated to it, Mr. Kemmish found out what exactly do I need to do. He has to walk in, show him a valid identification, pay $100, and he gets a state-issued identification card with his letter. There's nothing extra. Nobody sends him to another doctor. There's just the last step. And California has said you don't need to take the last step. We consider the letter of recommendation, whether it's oral or written, I guess letter can't be oral, but an oral recommendation, a letter of recommendation, a card issued by the health department, or a card issued by a health facility. And their statutes, if you look at the statutes I included, pretty much equate all of those. That goes to the word equivalent. A registry card or its equivalent. And the reason that statute was written that way is because Arizona doesn't tell other states what they have to have in order to issue medical marijuana.
So, but couldn't the legislature have simply said, if a person qualifies to possess medical marijuana in another state, that is what the equivalent is, or words to that effect, rather than simply saying an identification card or its equivalent?
They could, but I'm assuming when they when the AMMA was passed, they probably looked to the laws of other states. As many times that's what happens when a legislature passes a law. They look to the laws of other states and saw that, well, people use registration cards, but also, hey, California, our neighbor, does not. So we're going to call either a registry card or the equivalent, whatever you need in your state.
In your view, the important part of the statute is the language that emphasizes that it's essentially documentation that allows that visiting qualifying patient to possess
Absolutely.
medical marijuana in their home state.
Sorry, absolutely. The state wants to jump past the plain language of a statute and that it's ambiguous, and state that these two statutes, if we read it the way that Mr. Kemmish wants it to be, they're in conflict with each other. They're not. He wants to jump past statutory construction and jump right to what was the intent of the electorate when they passed this initiative. I agree with the trial judge. You don't jump past that. You look at the plain meaning. There's nothing ambiguous about this statute. A registry card or its equivalent. And the reason they said that is because not every state requires a registration card. There are 3 states that don't. We can't tell at least another state what they can give medical marijuana for. Now we could, but the legislature didn't, limit those people coming into the state if they didn't have the correct debilitating disease. We can also tell them what they have to have in terms of to purchase medical marijuana. And I can give you a very absurd hypothetical regarding that. Wisconsin doesn't have a medical marijuana act. They could say, okay, here's the deal. We're going to have a very restrictive one. And you can only get it for stage 4 cancer or AIDS, which is on our list. Doctor has to do that, but then in order to go to a dispensary and purchase, what you have to first do is go up to Green Bay to the Packer Pro Shop and buy one of those styrofoam cheese heads. That will allow you to purchase and possess medical marijuana. Under the state's theory, that person can't use marijuana here, even though it's a more strict statute, because he doesn't have a registry card. The opposite to that is they could have their health department issue the cards, but say, we're going to give it for the common cold and really bad acne. 2 things that are not listed as a debilitating disease in Arizona. That person would be able to purchase and use, or not purchase, but possess medical marijuana here because they have the right card. And that's why the trial judge's finding is correct. It has nothing to do with what you possess, but it's what its force is. What does it do? What the state wants to do, I believe, is what this court has said in State v. Mastis is not allowed, and that is to add to a voter initiative. He wants to criminalize something that the statute doesn't criminalize. In Mastis, passed a statute that says it's criminal to possess marijuana on a college campus or university, a public university or college. And the Voter Protection Act, which was passed in 1998, says you can't add to a voter initiative, and that is adding to it. And the crux behind the Voter Protection Act was because in 1996, Arizona passed a less restrictive medical marijuana act, and the legislature turned right around and thwarted it and outlawed it. And so the voters passed the Voter Protection Act, then they passed the Medical Marijuana Act in 2010. So the appellant wants to skip over the plain meaning of these words. I don't believe there's any question as to what these words mean. The legislature got it right. They didn't exclude things. They didn't exclude California. There was language in the ballot that talked about that. But actually, if you look at that, the state cites to Andrew Myers, Arguments for Proposition 203. He was the campaign manager for Arizona Medical Marijuana Policy Project in Phoenix. He was the person behind the bill, or the initiative. He clearly wanted it to pass. He was going to say anything he could to get voters to vote for it. If you go further on in appellant's appendix and you start reading the arguments against Prop 203, everybody's talking about the fact that Andrew Myers wants marijuana to be legal in Arizona, and this is just the first step on the way there. In fact, one of the first proponents or opponents to Prop 203 is the Arizona Department of Health Services. They didn't want it to happen, but they will organize it and administer it, I guess. I find also very telling on the opponents to Prop 203 on page 18 of appellant's appendix. And these people were opposed to it because they believed it was going to cause more criminal activity. But there were 9 of the 15 elected county attorneys in the state of Arizona, along with a number of sheriffs and other law enforcement, who were opponents to 203. In 2010, in 2010, the elected county attorney for La Paz County signed that document. His name is Samuel E. Viederman. Look at the signature on the order granting my motion to dismiss is Superior Court Judge Samuel E. Viederman. Obviously, in 2010, he knew what the statute said, but in 2017, when he heard this case, he realized the plain language indicated that, or its equivalent, means the registry card out of California. The state wants to skip over the plain language of the statute here. There's nothing ambiguous about registry card or its equivalent. There's no definition of what registry card is in another state or what another state has to have, nor is there anything limiting what you can get medical marijuana for in another state. Mr. Kemmish, as we stipulated, is eligible for medical marijuana in California. There was nothing improper about his letter of recommendation or his health facility identification card. He had the proper amount of marijuana. He fit the statute under 362804.03C as to a visiting qualifying patient, and so did his letter of recommendation. I would ask that you affirm the trial judge's order. Thank you.
Thank you, Mr. Coolidge. Thank you. Mr. Smith.
Thank you, Your Honors. As an initial matter, Your Honor, the full faith and credit clause does not require Arizona to substitute its statutes for the statutes of California if they envision a conflicting policy. The AMMA has a definition for visiting qualifying patients, which refers to a debilitating medical condition, and then has a separate definition for a debilitating medical condition. So, the defendant's argument that under the AMMA, the Arizona has to accept any medical condition from any out-of-state resident who has a medical marijuana card or recommendation does not comply with or does not follow the statutory scheme under the AMMA. A visiting qualifying patient only applies to somebody who has a debilitating medical condition as defined by the AMMA. And while it's stipulated that Mr. Kemmish is a visiting qualifying patient, for the broader principle that under Arizona law, if there was no stipulation, Mr. Kemmish would be allowed to possess marijuana even if he was not diagnosed with a debilitating medical condition, I would argue is an incorrect application of the definition of visiting qualifying patient. Going to the specifics of 362804.03C, it states that the registry identification card or its equivalent has to be issued under the laws of another state. Marijuana can't be prescribed, but analogous to a prescription, a doctor does not issue a prescription. A doctor writes a prescription and gives it to a patient. Similarly, a doctor does not issue a recommendation. He writes a recommendation and then gives it to a patient. So a recommendation is not issued under the laws of another state. It's authorized by the laws of another state, but it's not issued.
So in your view of the world, the term issued is a term of art that could not possibly apply to a formal opinion written by a professional like a doctor.
Yes, Your Honor. It's a document that's issued by another state. Similarly, the defendant argued that.
What if California had a system that allowed the doctor or required the doctor to file that letter, and it would get a stamp? There's no card that issues from it. There's no formal document that comes out of it, but there's a stamp applied to it. Would that make it an issued document?
I suppose it would depend on what the specifics of how the stamp is applied. If it's something like a recorder where it's just recorded, then I'd say it'd be more in line with recorded or filed rather than issued. The defendant's argument is also that the recommendation that the defendant had is no different than a written certification under the AMMA, and I agree with that. But a written certification under the AMMA does not authorize somebody to possess medical marijuana under the AMMA. You have to take that additional step to apply with the state agency, which then reviews the application and has a clear circumstances or criteria for reviewing it and approving and denying it before issuing the card. So I would agree with the defendant's argument that his recommendation under the CUA is the equivalent of a written certification under the AMMA. And under the AMMA, you cannot possess medical marijuana with just a written certification.
But Mr. Smith, going back to the question that Judge Winthrop just asked you, it doesn't say in the AMA under 280403C that it's issued pursuant to a department of a foreign state. It says it's issued under the laws of another state. So all we have to look at is whether the documentation that would allow them to purchase marijuana was issued pursuant to the laws of that state. And if the laws of that state recognize the letter for them to purchase marijuana, isn't that sufficient?
I would say no, Your Honor. The registry identification card is a term of art under the AMMA that has a specific definition under the AMMA. If the statute was only intended to allow anyone who has any documentation from another state that lets them have medical marijuana, then it makes no sense for the statute to use the registry identification card, which has a specific definition under the AMMA as a document issued by the department.
But when you talk about the specific language, that's how you get a card in Arizona. Agreed?
I'm sorry, Your Honor?
You talk about the issuance by the department, and it's defined in the AMMA, and this is how it's defined. But this section that we're talking about, people want to come here, and they have a debilitating disease. Their state says this is fine. Arizona says you can have medical marijuana. They come here believing. What I'm missing is when you keep talking about the definition of the identification card, that is Arizona specific, not California specific. Agreed?
Yes, Your Honor, but
is there anything that says this applies to every registry identification card from any state? I mean, is that making any sense? Your argument is it's defined in the AMMA, but when it's defined in the AMMA, what it's defined about is Arizona. This is a section that talks about what happens when you don't live in Arizona.
And Your Honor, my reading of the equivalent, or its equivalent language means the equivalent of a registry identification card is a state-issued card. But specifically when it comes to California, the identification card under the medical marijuana program, for all substantive purposes, all intents and purposes, is the equivalent of the AMMA. The medical marijuana program in California was adopted after the Compassionate Use Act was enacted.
And California could have said, All of you Compassionate Use Act people go get a card, but they chose not to, agreed?
I believe they couldn't because the Compassionate Use Act was adopted via a voter initiative, and that California has a similar law in place that prevents the legislator from changing a voter initiative. The CUA doesn't say you have to get a state-issued card, so I believe the medical marijuana program was adopted in California. It was done to clarify the Compassionate Use Act, but they couldn't make it compulsory to get a state-issued card because that would conflict with the CUA, which was a voter initiative in California, and it would be a similar situation to the Maestas case, wherein the Arizona legislator made it illegal to possess marijuana on a college campus where the statute wouldn't allow that. If California, in adopting the medical marijuana program, wanted to say you have to get a state-issued card, that would conflict with the CUA, and since the CUA was a voter initiative, they wouldn't be allowed to do that either.
Thank you, Mr. Smith.
Thank you, counsel. We appreciate the arguments presented here this morning. We're going to take this matter under advisement. We'll issue a written decision in due course. We are adjourned. Thank you.